It really depends. I usually prefer short and sweet. I usually like to not leave any kind of ambiguities in a letter. If you know what is inaccurate on a credit report, tell them. Don't hide the ball. Tell the credit reporting agency, tell the furnisher something is removed off the credit report. You know what will happen if items are removed off the credit report? Consumers are happy. My clients are happy when they reach out to me and tell me that something was removed off their credit report. And it's really important to make sure that you do that. And dispute funnel, what is a dispute funnel? A dispute funnel just means multiple rounds of disputes. Don't just take one set of dispute results, and think that that's it. You can send another round of disputes. You can send multiple rounds of disputes. The overall number of disputes, I usually recommend that there be at least 2 to 3. There could be more. But again, as I mentioned before, there are times where even one dispute could be enough. It depends on if something is inaccurate, or sorry, if the letter is on point in describing the inaccuracy. And then now the credit is fixed. Now what? Sometimes a consumer's credit is fixed, but they ask me, does that mean that there's no lawsuit? Well, it depends. If you suffered actual damages, and this is what I was talking about earlier with the complex legal analysis about actual versus statutory damages. If you suffered actual damages already, then you may still be able to recover for those damages. If, however, you did not, and you're still, you're pushing a statutory damages theory, you may still be able to sue. Just understand that the judges are not going to necessarily be happy that you're standing in front of court, you're standing in court telling them that it's been fixed, but you're still suing. And you need to understand that these are, again, complex legal analysis that takes place of whether or not there are still going to be damages that rise to the level to meet the materiality aspect of the Fair Credit Reporting Act. And so filing suit, it's really important to remember that when you file suit, when, where versus who and what claims. When will be, there's a statute of limitations of the Fair Credit Reporting Act of between 2 and 5 years. Again, the Fair Credit Reporting Act is far more complex than the Fair Debt Collection Practices Act. When it comes to legal analysis, the statute of limitations is something that varies, and it's something that will require some analysis. Where to sue? Usually we sue where the consumer is located. You can also sue the credit reporting agencies where they are located. So you can sue Equifax in Georgia, you can sue Experian in California, and you can sue TransUnion in Illinois. But for the most part, we sue where the consumer is actually located versus who. The furnisher, again, is the